A very good afternoon to all. As we come to the final session of the second NLUJ RT paper presentation and discussion series, we are honored to host the panel presentations, a platform where our esteemed panelists will be sharing their insights to deepen our understanding of the right to education and its on-ground implementation. This session is not just a culmination of our discussions, but a step towards building the capacity of law students to critically engage with legal and policy challenges. We look forward to an enriching exchange of ideas and perspectives. It is my honor to introduce today's esteemed panel, which includes policy professionals, academicians, and activists working in the field of education. First, we have Ms. Pooja Pandey, who is currently working at Sambodhi Research and Communications Private Limited with the capacity building team, offering a range of research and training support to government and non-governmental stakeholders. She is also a PhD scholar at the National Institute of Education Planning and Administration. She was previously engaged as a senior resident fellow at Vidhi Center for Legal Policy, where she has worked on issues relating to child rights and education. Second, we have Mr. Manav Singha, who is a senior lead at East Zone Operations at Indus Action, which is our collaborator for today's event. Mr. Singha holds a master's degree in social work and has an experience of working as a social development professional for more than 14 years. His expertise lies in educational reform and community building. Third, we have with us Ms. Nisha Varnekar, who is a consultant for CSR strategy at Tally Solutions and a doctoral researcher at the University of Duisburg-Essen, Germany, specializing in education and gender policy. She previously led the education vertical at Vidhi Center for Legal Policy. Fourth, we also have with us Ms. Rajkumari Michael-Samy, who is the program manager for early childhood care and education at the Right to Education Initiative. She specializes in addressing inequalities in early education, focusing on marginalized communities, including children with disabilities, migrants, refugees, and asylum seekers. Her work emphasizes the long life impact of early education on social justice and inclusion. We also have with us today Mr. Dibarga Roy, who is an advocate based in New Delhi. He is the founder of Project Sathi and a research fellow at Vidhi Center for Legal Policy. He has read law at Gujarat National Law University, Gandhinagar, and has been instrumental in pioneering the implementation of Section 121C of the Right to Education Act in Assam, while also working to expand its scope. We extend a warm welcome to all of our esteemed panelists and look forward to their valuable insights, guiding us towards a meaningful and enriching discussion. Participants are also encouraged to share any questions that they may have for the panelists via the chat box. We will try to take them up towards the end of the session. And without further ado, I would like to call upon first Ms. Pooja Pandey, who would be speaking upon the role of law students in promoting awareness about the right to education.
Hello, everyone. Thanks, Rup. Thanks for the introduction. Very happy to be introduced to all of you. Last year, we were having the same conversation in Jodhpur, and this time, at least, the conversation is happening virtually. So, very happy to see the conversation continuing. I might not take the entire 15 minutes because I like to have more questions and answers towards the end, and I'll also not be using any PowerPoint presentation because the topic is such. Now, when I heard about roles of law students, I automatically assumed that this is going to be the last leg of the conversation because we are going to talk about everything under the sun, which is institutions, colleges, policies, advocacy, law, and then we'll come back to the student. But it's very heartening to see that we are starting with the students and we are taking a bottoms-up approach in this entire discussion. So now we're talking, what is the role of like law students in sort of increasing awareness about RT or even like furthering the entire discourse on RT, which automatically puts a lot of onus on the individual or the law students themselves. Like this is something you would automatically assume that the onus is coming on the self or the person, and then it's going on and percolating to systems and institutions. Now, to understand this entire debate, I'd like to break it into four kinds of buckets. Number one, RT vis-a-vis what? So here we are primarily talking about RTE vis-a-vis the legal advocacy and the litigation. Now, both of these aspects of legal advocacy and litigation are definitely very important. But if you see the trajectory of a law student being a student and then practicing at different stages and junctures of their life, either of the two might take precedence over the other. So when you're enrolled as a law student, maybe legal advocacy is something you might be a little better placed at as opposed to litigation. And once you're transitioning out of your law colleges and you're going into the field of practice, either as like a litigator in the court or in corporate law and whatever that field is, litigation is something that you might be a little better placed at. Both of it, of course, equal importance. It's just that at different junctures, either of the two might take precedence over the other. So I think that distinction is very, very important to understand. Now, for legal advocacy and litigation both, there are three systematic levels that one needs to be very, very mindful of. This is also very famous, like this is a very famous framework which is used in a lot of other cases, which is of micro, meso, and macro. These are the three levels that we break the conversation at. And this is another framework that is very, very applicable to this conversation that we're talking about. Now, when we begin with the micro starts with the individual, the person, the self, which is the law students themselves. Now, education or right to education is a field which a lot of you can also testify towards this. This is not the quintessential glamorous field that is going to fetch you a lot of money. This is not the kind of field that a lot of law students voluntarily go towards or opt towards as an area of practice. This is not your shiny lamp fellowship or any other fellowship that you would go for and it's going to like, set a trajectory for you in policy or in research. Corporate law, definitely there's no inclusion of right to education conversation. And even in litigation, that often sadly becomes a subset of a kind of litigation that happens in the court. So for you as law students to be able to even notice right to education, then it has to be driven by passion. It has to be driven from something which has to be very, very internal as a driving force. So that is the first step in any micro conversations that we're talking about. Now, if the intent and the drive is there, the second step is to develop your knowledge in the field. Now, you have to know about the RTE legislation, you have to know the jurisprudence really well. And RTE Act is a central act, but it manifests in different format at the state level. So there are state-specific rules and regulations and a range of acts that like operationalize at the state level. And then there's the constitutional framework, there's an entire gamut of international education rights and laws, and then there's the education policy landscape. So at the micro level, you first have to have your knowledge in place very, very, like you have to have a very critical and an in-depth understanding of the legal and the policy landscape of the RTE Act. Once you have the knowledge, the second is the skills enhancement. Now, this skill enhancement, of course, has to be legal research and writing skill, but at the same time, especially because we are talking a lot about RTE awareness, which is going to involve a lot of community interface, you also have to know about community engagement techniques, about documentation, about writing, and in fact, sort of presenting what you're finding in a very legible manner. Because as legal students, you are trained to write and think in a certain way. You have to constantly decode that and keep simplifying it as and when you go, which is a skill unto itself. Once you've done these two things, number third, at the individual level or the self level, you have to build your personal POV, as we call it, personal point of view or a personal practice. Now you have to, how do you do that? You can all read about everything under the sky, but you will never know how a government school is functioning or education is functioning till you've seen it happening. And if anything, the conversations that we are having in the first half today is a very good testament of the fact that many of you went to the school and so many of your myths and all, whatever you've read about the law or in the law, sort of like completely got demystified. So you have to know the field, you have to visit the field, you have to observe the field. And then there has to be a lot of reflection and documentation that comes with it. And then you also have to keep building your like personal portfolio around RTE Act. How can this happen? You can intern with a lot of places, you can be a part of the existing networks, you can do a lot of networking, continue to build your personal POV. Now, these are the three key things that you start at the macro level, which is the level of the self. Now we come to the second M. Now the second M is the meso. So once you've done things at your individual level, vis-a-vis your knowledge, your skills, and your personal point of view, you then move to the levels of the collective. Now, when you move to the levels of collective or the meso, you have to now start actively looking out for like-minded people within your institution and outside your institution who are already working on this or are interested to work in it. You have to find them and you have to build peer learning networks. This can be within the college or in between the college. This can be through collaborative research practices. This can be through skill sharing sessions, joint advocacy initiatives. And then second part of this is the community of practice. So in one part, you're sort of strengthening your learning networks, and the second part is directed more towards the community of practice or practice oriented. How do you do it? You have to identify and tap existing networks. There are many networks. In fact, some of us in the group and the conversation today are also a part of a community of practice on RTE itself. So it's very important to know these groups and join these groups. And at the same time, you have to also, in fact, in some cases, tap your alumni networks. You never know. Even within your colleges and within your institutions, there must be a lot of people. I can definitely vouch for NLU Jodhpur. There must be many of your alumni who are working on these issues. So you have to know what they're doing and sort of learn from them and sort of actively network with them to be able to take it forward. So this covers the second level, which is the meso level. Now coming to the third level, which is the macro level, which a lot of other co-panelists of mine will be talking about in much greater detail. So I'll not be touching it like as in depth as I would like to. But at the macro level, which is the institution or your college level, of course, there has to be an academic or a curricular integration of RT Act within your existing curriculum. This is something I'm sure extensively is going to get discussed eventually in the presentation. And there are legal aid clinics, there are like legal education clinics. In that, RT has to be, or education has to be given a particular emphasis within the existing architecture. And then once you have that academic integration, there has to be systemic support by your institution at every juncture, which includes support of infrastructure, resources, mentorship, and even industry partnerships. Because there's only so much that can happen at the individual level and at the meso level. So that systemic support then ties all of those together and then becomes like a continuum. So the second element that we were discussing just now is the micro, meso, and macro. Now coming to the third part. Let's say that you have taken care of all of these things. You as a individual, like you have done your knowledge, like you know everything, you built your network, you have your collectives, and you have the institutional support in place. What is the end goal eventually then? So I think the end goal and the clarity of the end goal has to be very, very clear, where you as law students who see yourself as the mean, eventually then go and support the parents and students in accessing their right to education. And in this very platform, in the last year, we were talking about the fact that the client and lawyer relationship in case of the RT Act is very, very distinct. It is not like in any other quintessential legal area where a client is going to come and approach to you and he is going to tell that these are the grievances, can you help me with this? This often does not happen in case of RT, and this is something a lot of other panelists and many senior people who are also the part of the conversation today have brought out before. That's number one. The client is more often than not going to come to you to say that there is a grievance. You have to go to the client in this case. You have to find the client in this case. And number two, monetarily, it is not going to be as lucrative as the other fees. These are the two things that you definitely need to keep a note on and keep reminding yourself as a law student, why are you doing what you're doing in the first place and why is there a merit to continue this? And thirdly, no matter what career path you choose, even if you choose corporate law, even if you choose litigation, you need to go into policy and research space. As people, like again, my panelists can vouch for this, as people who have been working in different fields in these reasons, some of us are into litigation, some of us are into research, there's always a way and a scope to integrate the conversations around right to education. It is your it is your point of view once again, and it's your intent and it's your caliber to sort of find those spaces and maybe sort of plug those conversations around RT in whatever areas that they're doing. And keep reminding other people also that this is why it is important, why do you need to do this, and what is the merit of doing this. So this entire gamut of end goal is something that you need to keep reminding yourself again and again. And whatever you are doing at the level of micro, meso, and macro level, treat that as a preparatory phase, then when we don't do this end goal of putting the parents and the children. And lastly, coming on, now we have talked about some capacities, these and that. Now, if you think of some practical pathways or some practical examples of how we can actually do this. Now, it's a very happy coincidence and happening that even in the group itself, we have many people who showcase those things and what they are doing. And then I started to be the organizers as a very classic example of how you sort of make RTDs for legal and practices. Then we have Nagarada to the group who is being actively like NLU group being actively doing other things. So there are multiple ways that you can sort one related clinic, where related clinics RTD become a separate section of analysis or even research. And again, as I was mentioning, and we go to the very fantastic example in this case, where you have RTL, you have medical research on RTL. Then there are also even examples, especially at NLS like Bangalore or other colleges, where law students or these cells of consortium, they go to the schools and then collaborate with them. So they run level interventions. Now that level intervention can be either on research, either on sort of capacity building or in students at an individual level. So law can also happen when you sort of collaborate or partner with schools particularly. Then the third element, especially with the younger generation, which you guys are very good at and fantastic at, is the social media advocacy. You find ways to write about it, sort of break RTD down, because law is very technical and it will be very jargon heavy for a lot of people. Now if I write a RTD, sort of break those things, maybe a small campaign, sort of know your RTD, how do you file a complaint, which is another agency that has been doing a lot of work to do this. Many of you must have followed the work. If you have not, please take a look at my doing. A lot of social media advocacy or engagement can happen. I consider a lot of students that start writing and reading only. Nobody starts when you start your own blog or that has to contribute to other blogs and podcasts that are happening in other like being posted by other domains. Because by doing this, you don't just build your own point of view or your own portfolio, but you also contribute to the overall discourse which is happening on IT. Then collaboration with NGOs and civil society, of course, there are many organizations such as International and many other organizations doing fantastic work. And especially if you want to understand what's happening on the ground and what are some of the ground level challenges, collaborating and engaging with such NGOs either as a research assistant or as an intern is a very important and a critical thing to do. It can give a much greater insights to a lot of students out there. Then there are ways that you can directly support the end beneficiaries, starting from the levels of your college itself. Of course, legally it is one thing, but there are many cases where the students themselves have formed collectives on their own record. And they are doing either legal literacy workshop or they are supporting grievance redressals, or they're helping parents in filing complaints. They're also sort of helping students in getting admission to 12 on C or other places as well. So you can always start supporting people directly at a very young age from your legal colleges, like from the age of your legal education. And lastly, because there is a great trend and interest among a lot of students who move towards policy, advocacy, and research, that's another area that you can see, because Nisha and I both of us used to work at the so we can definitely take the example of the So you can also start understanding how law operates, how law is drafted, and how policy recommendations are made. And you can sort of associate yourself with these organizations and help with policy advocacy and research support. And finally, when you talk about capacity building, it's not just your own capacity building. Once you build your capacity, you also always have to remember to pass it on to other paralegals, to other cases. How do you then build the capacity of other people and take the movement forward? So that will be the last leg of the conversation that you can take care of. I don't want to keep it very monologue-y or like I don't want to talk unilaterally, so I'll stop it here. And I'm sure we'll be having a lot of question and answers towards the end. So that's it from my side.
Thank you so much, ma'am, for your insightful words. We are sure that the students will also incorporate that advice because we certainly will. Any questions if the participants have, they can just direct it on the chat box. I would now like to call upon Mr. Manav Singha, who would be speaking on the practical issues in implementing Section 12(1)(c) of the Right to Education Act.
Thank you, Dhruv, and thank you, Pooja, for setting this context. I think it's just after you, I think it's the more viable to have discussion on certain issues like 12(1)(c), because we already shared like what could be the role of student professional from a law institute. So before I start, like it's a really, I'm really thankful to National University of Law, Jodhpur, and really extending my heartful gratitude to the faculty members, student organizer, because I'm sure like for a long time you have to do those preparation, other than your day-to-day activity, day-to-day courses. Like you have to invest a lot of your energy around this thing. That's why such a beautiful event is now happening today. Even you have already started, day before yesterday. So, and thanks for recognizing this RT Act as a really viable issue to have discussion, in such platform. Because since last 14 years, I think uh, this is something this legislated rights, I think, is very ignored, across the professional sector. I'm naming law, policymakers, NGOs. So nobody is ready to talk openly, share openly about right to education nowadays. Even recently, I have been in a very senior level event. All those senior professionals or bureaucrats, decision maker, they were there. As you can imagine, starting from the center level to state level, and we are having discussion around national education policy 2020. And I was there for throughout the day, and you'll be surprised to know that none of a single speaker even referred this Right to Education Act. And if I tell you the portfolio of those people, like, you'll be surprised to know. None of them mentioned about the Right to Education Act. And we had conversation for throughout the day around NEP 2020. So this is the situation. So these are very viable issues right now. I think people like you should come forward, and we are there, to work, engage with you. So as I'll go into it in the deep around RT 12(1)(c) only. I'll not cover all those sections around Right to Education Act, because in the section where from I am right now, we are working on Right to Education Act. Since last 5 years, I am working in the Eastern region to streamline this thing. So I have some very on-ground issues. Some of the things I cannot share you openly, or I can't name those dates and those issues. But yeah, I'll try to cover it up. And maybe in later stage, like if people are interested to engage with this thing, like I can have one-on-one discussion in a group or with your people. So as we all know, like, this has been 14 years now. So we are still struggling to execute this RT, Right to Education Act, in our country. And currently, in respect to RT Section 12(1)(c), we have certain partnership with the different state government. We have worked with 14 states. Currently, we have partnership with like Andhra Pradesh, Odisha, Bihar, Meghalaya, Tripura, Uttarakhand, in some form Tamil Nadu as well. And based on our experience with this partner state, I'm going to present certain things, certain stages or steps that most of the states are following who has some intention to do RT 12(1)(c) in their state. And I'll also try to pick certain gaps or areas or errors where probably people like you who are having a law background can intervene and extend your support or your expertise for a public good. Because RT Section 12(1)(c), I would say it's the largest affirmative action in education nowadays. Across our country, there are no such initiative on right to education or in education domain where government has taken such affirmative action for a large volume of people. And this is something, for me personally, because I'm in this sector for last 15 years, and what I've seen here, that's why I'm in the section right now. So this policy has an immense potential to challenge the age-old, societal structure, age-old societal vulnerability of certain sections, certain group of people. This policy has that capacity. So before I start with, I just, I'm just going to, I was preparing for this presentation. So I have just categorized 4 different category of states where, in terms of RT 12(1)(c) implementation. So the first category of states are like those who don't want to implement RT 12(1)(c). They're just ignorant. They don't believe in RT Section 12(1)(c), and they don't bother about this constitutional policy, like West Bengal, Kerala, Punjab, Nagaland, Manipur. They don't have any intention to do that. I'm from West Bengal, by the way. Yeah. So they just ignore everything. Second category, second group of states are like who are doing Section 12(1)(c), but not enough confident, to make it transparent, set accountability for different stakeholders in terms of its processes and the delegation of system actually. So these are category of states, for example, like Jharkhand. They're doing RT12C, but they are not very fond of having a very transparent process or policy system mechanism. Third category of states, I would say, they're doing RT12C in an online method, which is we consider at Intersection is the best way to implement this policy. So they're doing online system for RT12C. However, their policies are not very up to date, which means it's been prepared in 2011, 2013, but not revised, not improvised based on our current socio-economic condition or other state norms. For example, Bihar, Andhra Pradesh, they have some or Madhya Pradesh, even some from also Chhattisgarh. And fourth category of states, for example, they are doing the RT online admission thing, as it's defined by the NCPCR guidelines, Central Government, Right to Education Act, and their policies are more of, I would say, like updated, or they have incorporated certain things based on the current need. So these are four category of states, and in this, each category of states require different kinds of intervention. Based on your capacity, you can choose and decide like which type of issue, which type of state probably appeals you more, and identify your pathway, as a lawyer. So now I'm coming to the different stages of its processes, and I will try to highlight certain areas which we consider as an error still going on, and sometimes there are intention from the bureaucrats, from the decision maker to resolve those things. Sometimes they lack those, encouragement to rectify those things. So first and foremost, RT12C, this section, RT Act actually talks about, it's for recognized unaided private schools, non-minority, non-residential schools, which provides 25% of reservation for economically and socially disadvantaged children in class 1 or pre-primary classes, whichever is applicable. So still, I would say in the eastern region, still there are a large volume of school, especially states like Assam, Bihar. There are a huge number of schools which are still operating as an unrecognized entity. In Bihar, there are 40,000 schools. Only 14,000 are registered now. Similar thing in Assam, you'll find a huge volume of schools are unrecognized. So this is the first step. And frankly speaking, if you think deeply around that, like if you talk with some people, some decision maker, you'll get surprised maybe. Still, there are officials who thinks like private schools, children who are studying in private schools are not in our responsibility. Sometimes they sound like these children and school are coming from Pakistan. Why should Indians should intervene there? This sort of sound you will find. This is not our burden. Like, ask someone else. So this is the area where we may intervene, and you can also understand that still there are a lot of violation of child rights are happening in those unregulated, unrecognized institutes. And Devarka knows. Devarka recently he is also dealing with such issues in Assam, so he could also add certain things. So second step, I would say, after the school got registered as a recognized entity, then they also need to get registered, or they confirm. They need to confirm that they are participating for RT12C. They need to declare the number of seats that are available for each year, and maybe in the online or offline platform, make it publicly available so that any child who are coming under that particular eligibility criteria can approach the school and get them admission, take the admission. So here challenges lies. In some of the states, things are going in offline manner. So whatever number schools, whatever number of seats available with the school, that is not known to everyone. It is kept secret in some time. Some, some colleagues or some official from that particular school may get advantage of those positions. Maybe a driver or a gardener can get help out of those to enroll their children in that particular school, but it is not open to everyone. School have, extreme authority over those seats, like whom they need to want to allot, or whom they will not, allow to take admission under those seats. So this is the situation in some state like Jharkhand. I mentioned initially, things are not very transparent in terms of availability of seat and in which class those seats are available. However, there are states like Odisha or nowadays in Bihar as well. They make it publicly available. Any child who is falling under that particular eligibility criteria can approach those schools. Here, I also like to point out that there are 1,500 schools in Jharkhand, which means every year there should be more than 20,000 seats available in the states. And if you check the current PAB minutes, that project approval board minutes, you can check, it's publicly available on the school education department website. So only 14 to 15,000 children are currently studying in Jharkhand for last 7-8 years. So you can understand, like every year, almost 80 to 90% seats are going missing somehow. There are gaps, there are errors, jahan pe 80-90,000 seats jo hai, which are meant for the vulnerable children, are not being utilized somehow. So this is the situation here. So maybe having a transparent online system could resolve those things, but that requires a lot of state intention, to do those things. Third stage is the student application part. So RT 12(1)(c) also meant it's a freedom of choice. It's encourage you to identify schools where you find your child would get best education. So through an online system, there are certain states where children are getting preferences. They are getting school choices. They can opt for 1, 2, 3, 4, 5 schools. However, if it is an offline process, then it's not open for the child. And the student application part as well, there are a couple of states which have made this very uniform process of application. But there are certain states jinka abhi bhi ye uniformity nahi hai. Schools are doing these things, the application process by their ways. So it's required again a lot of state intention to streamline these things. कि आप जो है हर school के लिए, if it is situated in particular state, as per the right to education guideline, you need to create a system where the system is equal for every child who are trying to apply for RT 12(1)(c). This system is still not streamlined in most of the states, and it's based on the whims and fancies of the school authority. भाई किसको देना है, कब देना है, क्या टाइमलाइन है, क्या फॉर्म होगा, ये उन पे डिपेंड करेगा. ठीक है, उनका करना है तो वो करेंगे, नहीं मरना है तो नहीं करेंगे. एंड बेस्ड ऑन द पेरेंट्स, आपका फ्रेमवर्क देख के, योर फिजिकल अपीयरेंस, एवरीथिंग, योर सोशियो इकोनॉमिक कंडीशन, they will take a call whether your child should get admission in their school or not. This is the situation in some states. Fourth stage is the online lottery system. So in many of the states, the lottery system is fully online. So based on the eligibility criteria, your neighborhood distance and those things, lottery has been done, and fair allocation has been made for the children. But in some of the cases, lottery is still going on at the school level. Although in paper you may find like lottery is very transparent, a lot of government official media persons are there to take over, to oversee the lottery process, but it has a lot of flaws. Okay. Here I want to one critical point. In some of the states, like where, this is my personal opinion, based on the demographic pattern, we should reserve certain seats for different group of people at the society. For example, in a state, if the tribal population is 6%, then you need to allocate 6% of the seat within that 25% for the scheduled tribe children. And there are states like Chhattisgarh who hasn't done that. And the situation is now 80% seats are being captured by the economically weaker section. Whereas there is a huge population who are coming under social disadvantage group. They are not able to get benefit out of that. So, having a clear distinction के कौन से category of, based on the demographic pattern, कौन सा category of बच्चों के लिए जो है कौन से percentage जाएंगे, I fond of that. Still, I'm sure कि in your group there will be some legal professional who say कि having a reservation within a reservation may not be a good idea. But ठीक है, that you can have discussion. Recently, I'm working with Meghalaya state, जहाँ पे 80% population are coming from a scheduled tribe category of people. Okay, so there another composition we are thinking like how we should pick up and how we should reach. We may reach to the right category of people like who needs this sort of benefits. So yeah, there are a lot of discussion can happen around that and the online lottery. But yeah, the best solution is to have an online lottery in the system. Third is the document verification and admission process overall. In some of the states, documentation and verification part lies with the school authority, where you will find a lot of manipulation, a lot of things are happening there. However, in some states, like Odisha, they have given all the documentation verification part to the block level or district level official. So the official will verify those papers and send a file to the respective school for final admission. There will be no role of school for document verification part. So that's a process that is going on. Still, there are a lot of things to be done on the document verification part, and technologically we can solve a lot of things. We can make API integration with a lot of other portals that are available with the government system. Automatic verification can happen. So these are some technological assistance we can support the state so that easily things get done. Next thing is the live student retention tracking system. This is a certain area where we need to be very cautious so that we can understand that students are getting quality education as well. Just for sake of doing RT 12(1)(c), nobody's getting, the private schools are not earning their revenue from the government. Rather, our focus should be whether the students is retaining with the school, whether they are performing well within the classroom, what's the classroom ranking system, what's the performance result. Those are certain things possibly we can take it up. And also based on that, reimbursement can be streamlined. Still across the country, there are issues with reimbursement system. Recently, I'm working with a state like so-called they are economically not very sound. They have lost more than 500 crore rupees in the last 6-7 years because their system was not profound enough and they are not able to submit the claim to the central government so that they can get their 60% share under RTE Act. Recently, we identified that. In 2016-17, they have last time they submitted that claim. So reimbursement system is not very organized across the state. There's no particular time कि भाई आपका reimbursement कब submit होना है, कब verification होना है, कब आपका bank में disbursement होना है. In some state, we're working with them to set up the PFMS system. We can check it in Google के PFMS system क्या है, उसमें कैसे process होता है. In some of the states, we are working for online disbursement, means directly state to school disbursement. There should not be any layer between school to state के आपका पैसा पहले district में जाएगा, उसके बाद block में जाएगा, उसके बाद school में जाएगा. So at every layer there could be a lot of things happen, and things get delayed. You'll be surprised, in one state we are working with them, we have recovered more than 70 crore rupees which are pending with the district department's account since last 2016. 2016 से मतलब 8 साल से वो पैसा उसके अकाउंट में पड़ा हुआ है. They haven't disbursed that fund to the school or neither they return back to the state. वो रखा हुआ है for some unknowing reason. So these are certain areas we can pick it up, like whether the schools are getting regularly reimbursement, because unless until the schools they are in paper they are not for profit institute. All the private schools, those who don't know, like you can understand कि schools का registration जो है not for profit entity के तरीके से होता है कोई भी school. But in reality they are earning profit out of that. मतलब इसको छुपाने की कोई मतलब नहीं है. It's a truth, real truth. So they need to create some revenue. So unless until they get their share of reimbursement from the state government, how they will survive? मतलब उनका teacher कैसे चलेगा? उनका infrastructure, logistics कैसे run होगा? So the reimbursement part is very crucial to onboard the schools for this process, and wherever it is delayed, ignored, कुछ दिन में ये problem जो है बहुत ज़्यादा मतलब damage शुरू हो जाता है in the process itself. So yeah, these are certain states में जिसके बारे में आपको बताया, and also in between I have highlighted couple of states जहाँ पे ये चीजें उस तरीके से नहीं हो रहा है, and we surely require support, assistance from people like you, those who are having law background. Several times I had discussion with Devarga regarding Bengal, Jharkhand, जहाँ पे चीजें ऐसा नहीं हो रहा है, पंजाब के अराउंड discussions हुआ है, and I'd be happy to come back again and have discussion with one-on-one you, anyone in the interstate to understand more around any particular state. क्या कैसे हो रहा है, क्या space है. That's what. Yes, that's all from my side. So, yeah.
Thank you so much, sir, for that insightful presentation. I think you have succinctly highlighted the regional disparities in the implementation of RT. So the impact of this, as you highlighted, is of course on one of the most vulnerable sections of the students. On that note, I would like to call upon Ms. Nisha Varnekar, who will also be speaking on the critical issues of access to education for marginalized groups.
Thanks, Dhruv, and thank you everyone for inviting me to this. And it's just been a pleasure listening to all the paper presentations, both yesterday and today. So I'll try to keep this a little bit quick. I am going to start slightly macro, but I promise there is something actionable if you stay with me. Okay, so when we think about the Right to Education Act, of course, we all know its primary purpose in the context and the time that it came about was universalization of primary education, right? And when we look at what that success has looked like for a very long time, we would say the success of the RT Act has been 98, 99% of our children are now enrolled in primary school. And, this is 100%, I agree, something we should continue to celebrate, right? But of course, when we start to think about marginalization, actual inclusion, or the true success of this act, we do have to think about access is, of course, not enough. We have to move on to a framework that looks at the entire process or pipeline of their education, right? So we say, okay, who is coming to school? Yes, very important. But then also who is staying in school? So what does our retention look like? What is the experience of that schooling environment or that schooling process? And then ultimately, what is the outcome of our education system, right? So are our children actually learning? And this is something that, of course, is more and more in the discourse, in the discussion today, as we move forward with, say, the national education policy, the focus on foundational learning. This conversation is not unique or new, right? But I wanted to sort of set the stage for this, because when we try to say who is marginalized, we are thinking about it across this entire pipeline, right? So when we say who is marginalized, of course, we know globally, but also in India, disproportionately, it is children who are from these economically weaker sections, who are socially, economically disadvantaged in some way, who are the ones that are most vulnerable in terms of not just being able to access education, but also in terms of saying dropping out eventually, or not being able to learn, or not being able to catch up with their peers over time, right? And of course, what that actually boils down to when you think about it is that, yes, the onus of education is on the school, but actually what is happening in the home is really going to shape our realization of the Right to Education Act, right? So households that are consistently more vulnerable to, say, something like an economic shock, say a household breadwinner loses their income, or there's a death in the family, something like the COVID-19 pandemic happens, the group of students that are most vulnerable are going to be the ones who then basically have to react to these shocks, and they have constrained resources at home, right? So then you see boys dropping out of school to, say, supplement household income, girls dropping out of school because the mother now has to go to work and they have to take care of younger siblings. These are all things that we know. These are narratives that we've all heard before, but this is essentially what marginalization looks like, right? In practice on some level. And then this, of course, iterates across the entire process, or that entire pipeline that I just spoke about. So you have infrequent attendance, which means children are learning less. You have poorer households where children are, not as well fed. Maybe they fall sick more often, which again feeds into this both learning and their attendance, and all of this, of course, also parents not being able to support the child within the household. All of this influences learning. And then overall, these are the children who are most sort of susceptible or most vulnerable to dropping out of school or not learning well enough, right? And then the question that I wanted to kind of come to is, how does the Act sort of respond to this? And the RT Act, even in its original inception, right, very much recognized that there are these vulnerable groups that are traditionally marginalized, right? So the RT Act says, let's define these groups. Let's define EWS. Let's define disadvantaged groups. Let's say, okay, out-of-pocket expenditures will be a problem. So we can't have that. We don't want capitation fees. We don't want the education of a parent in any way to determine whether the child will be in school or not. So we won't have screening processes, right? Any child should be able to be admitted into a government school at any time of the year. So something like a migrant child shouldn't be excluded because they come in the middle of the year. These kinds of things, right? So the Act is very much responding to what we're seeing as these disadvantages in our society when we try to characterize who these marginalized children are, right? And the Act is essentially being informed by what we're actually seeing on ground, right? So the reason that I wanted to set this context before getting into what I consider are the actionable pieces of advice might be too rich, but advice that I wanted to share with everyone here was, one, like I said, the law is being informed by practice. And this is an iterative process, right? Which means that as we go forward, we need to continue to see what's happening on ground and continue to think about how the law can iterate. And then two, like I said, the onus of education, yes, as per the RT Act, is very much on the state. But what happens in the house will determine realization of this, which means that when we talk about realization of the RT Act, there are all these other acts that come along with it, whether it's social security of the household, whether it's specifically something like Persons with Disabilities Act. There is an entire body of laws that exist in and around the RT Act. And it's only when we think about this entire structure together that we can really get to some of the nitty-gritties when we're saying, let's advocate, right? It's not as simple as saying, okay, we will just do what the RT Act says. This brings me to then my sort of first point, which is, as Pooja also mentioned, as I think Manav sir very clearly showed us, what actually happens on ground and how the system works from the formation of a law to ultimate implementation is incredibly complex. And I've just thrown in another wrench by saying that not only is it the RT Act and the education departments, there are all these other departments, all these other laws that we kind of need to bring into our purview, right, when we're studying this or looking into this. So as law students, there's something that I'd want to say, and this is coming from my experience as a non-lawyer, right? I'm trained as a social scientist, I'm an economist, but I had this great opportunity to work at Vidhi with Pooja, but also with a group of other lawyers. And really what I learned was there is this huge leverage and expertise that all of you are being trained in, right? Which is to understand the mechanics of how our laws are formulated and how they are ultimately implemented, and then what we can kind of do along that process. So what I wanted to urge you to do when you're in this process of trying to build your own capacity is, one, recognize that you have this incredible expertise that you're developing over these next few years of your degree. But then to also, when you're thinking about advocating, think about all the different stakeholders who are here in this process, right? All of us on this chat over the last 2 days, but also outside of this, we're a group of varied stakeholders who are all trying to work towards this common goal of universalizing quality education for our children. And there are these non-state actors and there are state actors. So if I start with non-state actors, I'm including in this researchers like me who are non-law people. I'm including our NGOs, our CSOs. And as a non-lawyer, I see a huge amount of benefit that can come from law students or practicing lawyers sort of working with us to help us understand how to navigate this system. So, I mean, very simply put, before I came to Vidhi, I have done a lot of research, a lot of policy research, and what I thought and considered to be policy advocacy. But there is a bottleneck when it comes to my abilities in some sense, because I can document something, I can write a paper, I can write a report, but until and unless I know how to navigate the system, through, say, something like litigation or through something like active policy advocacy with the right state stakeholders, my research sort of stays here, right? We'll listen to it, we'll talk about it, but I'm not able to take it ahead and actualize that, right? So I think there's a huge amount of capacity building that you can do for people who are from a non-law degree or non-law backgrounds who are working in this space. Then, of course, as Pooja rightly pointed out, as many legal aid cells have also been doing, the beneficiary, so the parent, the child, of course, that is an obvious stakeholder that there is a clear role for you to play there. And again, your role there could be coming from the same area of expertise. Because the system is so complex, there is so much information asymmetry, right? People don't know how to navigate the system. But there is another problem which I will also touch upon. But so helping people navigate, just say something like the grievance redressal system, going to them and highlighting to them, like Pooja said, right, that this is a potential area where you can be a client and I can sort of represent you and help you navigate the system, I think is a very powerful skill. And this is, of course, something that a lot of you have spoken about and understand already. One sort of thing I want to touch upon here, though, is, and I think many of us have had this experience on ground. So when I was working in Ahmedabad many years ago, we were doing like government school studies, very similar to the paper presentations we saw over the last 2 days. And we were talking to parents about, look, there are these clear violations of the act that are happening. The infrastructure is not up to mark. You don't have girls' toilets, etc., etc. Why don't you complain to your principal, right? And we were, as researchers, saying, we can't guide you as much, but can you complain to your principal? And they very clearly said, listen, this is free education. I can't complain. I don't pay anything for this, right? So when I say information asymmetry, it's not as simple as saying they don't know how to navigate the system. That is a part of it. But it's also this idea, and again, something we've all seen repeatedly, that people think of free education as something that is not a fundamental right to them. There is a huge gap in that understanding, right? So as a lawyer, again, but also for all of us, there is a duty that we can sort of, or a gap that we can fulfill, which is to try to explain to people how this fundamental right works, the fact that it is theirs, right? Thank you, Nalina. But yeah, an incredibly crucial thing. And I think her thumbs up was just, reiteration of the fact that we keep harping on about this, because this is an incredibly important point for us. Okay, the second bit that I want to touch upon was, like I said, the state actors, right? Or the state, when we think of the state as a stakeholder. And this is something for when you're trying to build capacity and think about your future in this space for advocacy. In education, our state plays multiple different roles in the system, right? So the state acts as a provider where they run their government schools. The state acts as a regulator where they regulate the government schools, but also the private schools. And then the state is also the legislator, right? So the state is also writing up these laws and policies and schemes that we are then implementing. So when you are thinking about how you want to work for advocacy, you can also think about which level of the state you want to interact with, right? Or advocate with and for. So for example, the paper presentations that we've been seeing is very much thinking about the state as a provider. So you're going into a government school, you're saying, here you are violating the mandates of the act as a provider, therefore X, Y, Z. When you think about the state as a regulator, I think a lot of what happens with, say, Section 12(1)(c), right? A lot of the time, the work that Debarka does, the work that Indus Action does, a lot of this is about looking at the state as a regulator and saying, look, these private schools are not doing what they're supposed to do, right? And then there's this piece of the state as the legislator, and I'll get to that in a minute. But I think in this space, when you're trying to build capacity and you're thinking about how you want to interact with the state, there's room to say, keep in touch with what is happening, where individual states are, say, changing rules, changing how they want to implement a 12(1)(c), how they want to, work with a no detention policy. These things are constantly changing, right? And you can think about the role you want to play. But one part of building your capacity is being in touch with what is actually happening on the ground in terms of the role of the state and how the state is constantly interpreting and reinterpreting how they want to implement this act in its many forms, right? And its many provisions. And then finally, coming to this point of the state as the legislator. And here again, of course, some of this is coming from the work that we did at Vidhi a couple of years ago. But I think it's very important for us to remember that the RT Act, yes, it came up in 2009, 2010, but it's very much a living document, right? And as such, what we want to be doing is to be thinking about where the act is going, what are the other acts that are sort of ancillary to it, and how can we continue to push the state to sort of move the needle forward in the direction we want it to move, right? So this is to say that when we're trying to, in terms of how we would build capacity to do this, what I want to urge us all to do is to think about not just looking at it from the perspective of lawyers, but also engaging with literature beyond the law, right? And I'm saying this as the non-lawyer because this is what really benefited me. As an economist, I was trained only to read economics papers, social science papers. And when I started to read the literature and law, that's when I was really able to grow in this space. So I'm urging you to sort of do it for the other way around as well, right? So like I said right in the beginning, the law, the way it is formulated and the way it changes over time is very much informed by what's happening on the ground, which is essentially something that social science is constantly trying to capture, right? So engaging with sort of interdisciplinary sciences to try to understand what is informing our law and how we can continue to inform it is incredibly important. Because at the end of the day, we want to be able to continue to push the needle forward, essentially, right? So for example, being able to talk about why the no detention policy was removed or changed, right? And why some state is saying that they will follow through with it and others are not. Other contentious policies, something like school rationalizations, right? Where many small schools are being shut down across the state. These are contentious aspects of the law that continue to be changed, continue to be amended over time, right? But understanding what was the original purpose of that when the law first came into being, and then why have we changed it over time is also incredibly important. And then to give you examples of, I mean, we've seen this happen as well, right? In the original institution of the law in 2009, like I said, children with disabilities were not expressly under the ambit of the Right to Education Act. And that was shaped by the fact that the conversation at that point wasn't actively saying mainstream children with disabilities. As that conversation moved forward, as multiple different parties advocated for that, then the RT Act came and recognized that. But we still have a long way to go, right? Because then we have our PWD Act coming in 2016, an entire section on how to truly include children with disabilities. And much of that is not recognized under the RT Act. Similarly, something like early childhood education, it's now a priority under our national education policy, but we don't have statutory backing for that, right? So these are just like minor examples of how the law itself needs to grow as we move forward. And this is obviously a huge space in which lawyers are the ones that will need to do this work, right? So when you're thinking about how you want to engage, this was essentially my piece. Try to approach it from a slightly interdisciplinary angle if you can, to try to understand how we can inform the law and how the law is being informed by society. And it is an iterative process that all of us are involved in. Try to build your own capacity, but like Pooja also rightly said, try to build the capacity of people who don't have your expertise. Because if we all kind of try to leverage our own expertise, we can work collaboratively to sort of move forward, right? Yeah, I think those were essentially my points. I will pause there.
Thank you so much, ma'am, for shedding light on the role of both state and non-state actors in RT advocacy. I think in your presentation, at least two ideas specifically stood out for me that has also been the approach of today's event. First, to engage with an interdisciplinary approach, because rather than being students of a discipline, we really are students of problems. And second was also the idea of education, not only as a privilege for citizens, but also very much a right and entitlement that is to be realized. Now, to further explore this very ideal, I would now like to invite upon Ms. Rajkumari Michaelsamy, who will also be discussing the implementation of the right to education through a human rights lens.
Hi, good afternoon, everyone. I have a presentation. Can you see my presentation?
Yes, ma'am, we can see.
Okay, I'll just make it full screen. Yeah. Sorry, if I make it full screen, it's a little difficult to see the audience. Let me just give me a second. Okay, can you see my screen now? Hello.
Yes, ma'am.
Yeah,
Yes, ma'am, we can see.
I'm sorry, I'm not able to see the chat now. In case if anything you want me to stop or any questions, you just ask the questions. Thank you to the organizers and thanks for this inviting me to this great discussion on the right to education discourse. And I'll be presenting, more about how to monitor right to education from a human rights perspective. It actually cuts through all the last three presentations, whatever covered in that aspect. I'm just more focusing more in a systematic way how we can do it. I was part of a human rights organization. I worked earlier. I used to do a lot of fact-finding missions, monitoring human rights violations, especially civil and political rights. But when we do that kind of a mission, the approach that we adapt is, we have certain standards and norms, and we interview people, and we go to ground. Immediately, we file a petition or we do legal interventions. But when it comes to socio-economic cultural rights, like right to education or right to health or any other rights that are from the socio-economic aspects, how do we do it, from a human rights angle? And how does it applicable in today's work that we all focus on? That's what would be my focus. One thing is that this is the structure of my presentation. So stop me if you have any query or doubt. Then just to give a glimpse, besides the constitutional guarantees that we have for right to education, as well as the Right to Education Act, we have also right to education guaranteed in the international human rights law, for which India is a party to it. So when we look into monitoring work or doing any interpretation on right to education, so we can also refer this treaties and instruments, and also especially the general comments, how these rights are interpreted. And this is very important when we do monitoring, to keep both the national as well as the international legal framework that is applicable to us. So to come to the point, why do we do monitoring from a human rights perspective, and how does it different from a research? So, we may wonder, we are doing research, all these aspects, but how does it different from a research, and why do we do monitoring from a human rights perspective? Monitoring reaffirms students, children, I put the word students because it's also applicable to students who are in higher education who do not come into the definition of a child. So that's why I use the term students, but it applicable to all children and as rights holders. My previous, the speakers mentioned, it is not a privilege. Education is not a privilege, and it is a right. So from that angle, how do we, it affirms that we are a rights holders. And monitoring shows whether the state comply with the obligations in whatever obligations they have committed, whether it is through the national laws or the constitutional guarantees. And also it helps us to identify whether the gap or the problem is with the policy or is it with the implementation. Nisha said, we have like the Right to Education Act. It covers more from the 6 to 14, and it doesn't cover the early childhood care education. So here we have an issue starting from the law itself. So that's how it helps us to identify where the problem is. And most importantly, monitoring allows us to identify and document educational inequalities as well as violations. As I go in my next slides, I'll give some examples also. How does it work in the field? So how to monitor? This is more of a methodological part. I'm just sharing this because I thought this would be from a capacity building point of view. This would also help. How do we monitor? The first thing is to define the plan and focus of monitoring. Why do we want to monitor? Just to give one example, the same example of...
Excuse me, ma'am. I'm really sorry to interrupt. I think the slides are not changing. So could you just check once?
Okay. It is not changing.
Now they are changing. Now they're changing.
Okay, I think it has some issues if I go to the full screen. Then can I use this mode?
Yes, ma'am. Yes, ma'am. It's visible.
Yeah, okay, I'll use this mode. Okay, so define the plan and focus of monitoring. It's very important to have a clarity on why do we want to monitor. See, implementation is a huge issue, and India is a huge country, and as an individual or as an organization, as a group, we may not be able to monitor the implementation across India. But we may want to do a very focused attention to a particular community or a group. So it is important to specify, why the purpose of monitoring. Like, for example, it could be for an amendment in a legal framework. Like the example I said in RT Act, you want to include early childhood care education, then you may monitor early childhood care and education, and then you may justify why you need to have a legal framework to support ECCE. And similarly, or it could be, to supporting a particular community to get access to equal education. So often we have the data, national data. Sometimes when you do a focused, research or focused activity data collection with a particular community, you may see variation in the data with the national average and what is the reality. So in that situation, so you can define what is the purpose of your monitoring. So you want to support a particular community in a particular region, then you can just focus on that. Or it could be a larger advocacy initiative or a campaign. For example, like in the presentation in the morning, most of you suggested we need to increase the investment in education. So it could be to increase the investment in education. So whatever it is important that we have a clarity in mind. Once you define the purpose, you plan the focus of a monitoring. That is your scope. What is the level of education that you want to monitor? Whether it is the elementary school or it's your pre-primary, or is it the Anganwadis that you want to monitor, or is it the pre-primary education, or is it the primary education, or you want to focus on secondary, or it could be higher education as well. So it depends on that. And the second aspect, you can also define the focus, the thematic focus. Like a lot of you in the morning talk about quality, or it could be access, or it could be just the financing, or it could be the implications in the privatization sector. So whatever it could be, you can have a thematic focus. And then once again, you can have a target group, whether you want to focus on a particular community, or for example, or you want to focus on children with disability. Or this morning you talked about caste discrimination. So whether you want to talk about children belonging to a vulnerable caste, whether it is about the education rights of that particular group. So it could be anything. And similarly, the geographical area, and most importantly, the context. Like we were talking about the impact of COVID. Similarly, there are a lot of natural disasters and health crisis, economic crisis happening besides the conflict situation. So it could be a thing that is that you want to do after certain context. And what is more important when it comes to monitoring from a human rights angle is identifying and assessing the human rights standards. That is more important, because when you demand, when you advocate for a change, it is important to have a clarity on the rights that are guaranteed in the Constitution as well as in the laws. So, and do an assessment of the education laws. Like for us, it's the Right to Education Act, as well as the constitutional provisions, and also the policies that are related to education. And similarly, when you we need to do an international assessment in terms of the general comments, declarations, and standards. Sometimes a state may not have a legal obligation, but they may have made a political commitment. But while we may not, ask from a certain aspect from a legal angle, but this can have this indicates a moral obligation that the state has. So look into the political, statements that states have made, or declarations the country has made, and that could be helpful in our argument as well. And most importantly, once you have the general data available, look into the different recommendations of the different treaty bodies provided during the country review. So that may be very specific, to right to education. So that's why it's important to look into that. And the very important aspect when we do human rights monitoring is look into the human rights indicators. So there are two options, like organizations like us, and there are many other organizations, including UNESCO, UNICEF. We develop a lot of human rights indicators to monitor right to education. So you could look into our websites or look into our tools and choose the relevant indicator. There are other organizations also, they are creating a lot of indicators for monitoring human rights education. So we could look into these indicators, choose the relevant indicators and contextualize to our situation. Or it could be something that we can develop based on the state legal obligations that the states have. Why we need indicators? Indicators makes advocacy more effective. It will help to provide concrete situational analysis. It can pinpoint the issues very, too sharp. Just to give some examples of indicators, the Sustainable Development Goals indicators, in relation to early childhood care education. It says the proportion of children under 5 years of age who are developmentally on track. And similarly, the participation rate of children in organized learning, that is the children who have attended at least 1 year of pre-primary education before they get into primary education. So these are some existing indicators, but indicators we can also develop on our own. And in terms of indicators, what are the type of indicators that we develop? There is one thing that we all clear. One is a quantitative indicator and a qualitative indicator. Both are important. Like this morning in the presentation, we discussed also, like when we talk about quantitatively, like there are no toilets available in the schools. There are no separate toilets for girls and boys. And what are its implications? So that's where a qualitative indicator makes it matter. Then it helps us to understand what would be the implication if there are no separate toilet for girls. So that's why we need to have both qualitative indicators as well as quantitative indicators. And also the indicators will be structural and process and outcome. I'll explain that little later. And also define your methodology, how you're going to do monitoring, whether it's on-site inspections, surveys, focus group discussions, media monitoring process. It could be any methodology, but you need to define, and it should all sync with the purpose and the scope. And the two important aspects that I really want to highlight in monitoring is a community-centric approach and ensuring student or child participation in the process. Just to give one example of how does it work and what is child participation means. Like I was part of CRY for quite many years, and when we work with children in different packets across India, that's one thing that we used to have a lot of interaction with children. That's one time when we do a lot of interaction that we identified the prevalence of corporal punishment in unregulated private schools, which children never spoke about it to anyone, even with their parents. But it took a lot of time for us to understand how does it work. And then we did a proper work about it. And then we reported to the committee in the Commission on the Child Rights, Child Protection Commission in Karnataka. So that's something that why it is important is often there are issues that are not visible to us, and children may speak about it. And similarly, there was another work that I engaged. What we did is we did a campaign in schools along with teachers in various states as part of my work in Amnesty, where we did awareness about prevention of child sexual abuse. And one of the first things that what we did to understand how do we do prevention and what are the ways that we need to do prevention, then we interacted with children. Of course, when we interact with children, there are various protocols that we need to follow. The child protection policies should be in place, and there are certain procedures we need to follow. And children shouldn't be forced, and there should be a safe and environment should be created. And then we identified the very many problems, that children are afraid of. And that's how then we interacted. We brought these things to the, to the CEOs and DOs at the district level and with the schools. And then we created kind of a safe environment. So these are some examples of why it is important to involve children. And similarly, community participation is important because we have a lot of democratic institutions, and that gives the space for parents to engage, and also this helps to strengthen the SMCs that we talk about. So the other element that are important is the disaggregation of data. So whatever data that you collect, ensure that you disaggregate, whether it is between urban or rural. And this is a framework, the UNDP framework, that helps us to identify how do we disaggregate data, but it's very much depend on the context and your purpose. Then it's very important to disaggregate the data. Then the other aspect is to gather data. One is through the available data, where the quantitative data from existing national and international databases. Now, based on SDG monitoring, there are a lot of data is also available besides, the statistical data that is available at national level. So you can refer both. And qualitative data through available research, and also the recommendations from the regional and even monitoring bodies to on this particular aspect, or through interviews and surveys and right to information systems. And that's a privilege, it's a very, the Right to Information Act is another landmarking act that provides us this access to information. So we can effectively use that as well to collect new information. Then what to monitor? The three type of indicators which I mentioned is the structures and process and outcomes. When we talk about structures, is it more analyzing the legislations and the commitment regarding the realization of right to education, whether the state has committed, whether there is a policy in place, whether there is a legislation in place. And the process is where it's more important when it comes to monitoring implementation, where you look into aspects related to whether the funding aspect, like if we talk about access to marginalized children, whether there is a special funding, whether there is a reasonable accommodation measures provided to children with disabilities. And also we talked, quite a bit of you talked about the trained teachers, lack of training for teachers. So those are things that involves in the process. And outcomes, what percentage of children are enrolled and what is the retention rate, all these things that we will look into the retention, the outcome aspect. Once you done the monitoring, what is more important is the structure of the report depends on the audience, target audience, you draft your report. And what is more important is ground your analysis in human rights standards. That's more important. And also these are questions that we could ask. What are the major problems identified? And what would be the ideal solution? Who are the persons who can, the decision makers who can bring about change? Like one example that we did in Bangalore is, like we had a group of interns. Most of them are from the law colleges. what we did is we did a monitoring on the status of Anganwadis in Bangalore. And there was a structured questionnaire. It was a collective work involving students as well as staff from the organization, where when we identified the problems, then we identified whom to go. There are certain issues, you need to go at the implementation level. So with the bureaucrats, for certain decisions, we had to approach the policymakers like the local MLAs and on that. And for certain issues, we had to appeal to the, Child Rights Commission. So accordingly, we did an appeal, and there were a lot of changes made in certain aspects that we highlighted. So these are some things. So it's important whom do we take the issues. And then finally, this has different advocacy strategies, Pooja has already talked about some in her presentation. So one thing is, what is very important is engagement with the duty bearers. When the duty bearers means, it could be the policymakers or it could be the bureaucrats. And constant engagement, submission of the report and presentation of the findings, and proposing alternative suggestions and solutions, which is more, and also community participation in democratic spaces. So if you are doing a monitoring work in a village, ensure the community talk about these issues in the Gram Sabha meetings. So then these are taken up for local implementation. Sometimes changes happens very fast when decisions are made locally. So certain local issues, like for example, sometimes if you work in the early childhood care education space, there may be no space given to have Anganwadi or to have a playground, and that issue can be sorted out by the local panchayat. So these are issues that you can take with the local in Gram Sabha. So the other people also, they may not give much focus or attention to children's issues. You can also encourage children to participate this Gram Sabha meetings and then present their concerns. And as legal students, you can also look into legal interventions, PALs and other forms of interventions that you could make. Then what is more important is public campaigns, and also depends on the gravity of the issue, or depends if the issue is not sorted out with the local duty bearers. You can also look into options of reporting to human rights mechanisms, both at the national and international level. So these are the different advocacy levels where you can look into for advocacy. Either it could be at the local level or the state level, or at the national level, depends on the problem that you have identified. So these are some of the tools that we have, and we will also have tools on other topics as well. So if you're interested, I can share the links that where you can look at these tools and you can download data. Thank you.
Thank you so much, ma'am, for your valuable perspective on ensuring accountability in RT implementation through a rights-based approach. As we are reflecting upon the mechanisms that drive effective enforcement, it becomes really important to circle back on how we actually started the discussion today, as to what is our role, what is the role of law students in upholding the ideals of the Right to Education Act. Now, to shed light on this aspect, I would like to invite Mr. Debarga Roy, who is the most suited speaker to speak on this issue of the role of legal aid clinics and litigation in strengthening the right to education.
Hi, thanks, Dhruv. Thanks a lot. I think the panelists before me have very well sort of put the context on, identifying issues. Pooja has gone about sort of speaking about how, what are the challenges, but yet opportunities in building a career in sort of right to education research and advocacy. Mana, very well from a CSO perspective has helped us identify issues at a systemic level as well as a ground level, which are sort of goldmine for us, law students to sort of build upon using the framework of law. And then Rajakumari madam as well as Nisha have sort of given their own analysis and perspectives, which I think definitely enrich our understanding of RT. without taking a lot of time in sort of developing this theory further, I'll actually put my comments and thoughts in form of an appeal to you all today. I think first of all, how legally clinics, right? That is sort of a collective entity of law students who can sort of really come together and take the justiciability aspect of right to education forward. To sort of contextualize this point, I think what is the gift of law that we have today, thanks to so much of advocacy, so much of movement, so much of reforms that have taken place today, is that right to education is a justiciable right. Now, how that plays out, that's sort of something that Professor Juneja and Pooja have sort of articulated very well, is that sort of it puts a collective duty on the duty holders. And oftentimes we think of duty holders probably as the state, as the school, as the parents. But I think today, what we need is a more of a participatory form of, sort of taking this collective burden. And I think as lawyers today, who don't just have the ability to identify issues, but as well as sort of we are trained in a system to sort of actually advocate on it and actually solve it perhaps. A lot of our research will not, as Nisha rightly pointed out, our research need not be just a publication. It can actually, be a stepping stone for the implementation on ground. Now, it's also, I understand that, when we all tell you all of this, it might sound a lot of, bit overwhelming. But I will, in my part, sort of try and make an attempt in sort of, giving you certain action pointers for you all to take today. I think each one of you who all are here representing your legal aid clinics, are here by the virtue of the fact that you've contributed to the event through a creation of a survey. And at whatever level, I would want you all and actually urge you all to think of this particular survey data that you've collected beyond a competition. What you get as a prize or some sort of acknowledgement is very little as compared to the effort you have put in and the information you have today. And I believe that, the presentations that I went through, I believe that a lot of you all had recommendations saying, the state should do this, the school should do that, and this policy should come. I'm telling it to you. So how can you guys actually go ahead and, what can you recommend to yourself? Being RT, being justiciable, right? Do you think, let's say one of you all in some presentation said that 2 of the schools you interviewed had, very serious issues with drinking water? Can you actually take it ahead to the authorities, use the power of law and actually get better drinking water facilities to those particular schools you surveyed? Can, let's say, those of you who found out that there were abysmally less number of teachers in a school that sort of deprived a child, can you sort of advocate on getting better teachers appointed and equipped to that school? I think those are questions that you need to ask from your own research, and that will be the first sort of action point I urge you to take. Next is, I'm aware of the fact that a lot of us legal aid clinics, given by, how we look at social volunteering, a lot of our legal clinics actually go and teach in government schools. While it's a very noble step, but I need to tell you all that we are lawyers. So we're not just, teaching sort of, fulfilling a volunteering need of teaching, but we're also engaging with children and, in that vicinity and that access to the school, we're able to identify a lot of issues. So I think what I would want to urge you all is use those opportunities through the lens of a lawyer. And the moment you see that, you'll see that there's so much of opportunity for you to just, improve the life of that child, more than just sort of teaching them that one extra remedial class. Can you engage with that child? Can you identify issues that they're facing? Can you, it doesn't have to be, I'm not saying that you're a lawyer, so you have to go and litigate in the court. Can you actually, read down the law and explain that to the teacher? Can you explain them that, this is something that the child, has to have? Or can you sort of, speak to the principal? Can you speak to the DO? And I'm sure that the moment you write as your legal aid clinic, you will have a certain amount of influence over the department. Maybe, by the fact that you're reaching out to them as a legal aid clinic would help you get a meeting itself with the district elementary education officer. So can you actually put these sort of information issues, forward before them and actually get some effective remedy for that school, for that sort of children, for that sort of children? I think that's the real question we have before. And even beyond that, I understand all of this may not be difficult given, limited guidance we have, limited exposure we have, and a lot of times conflicting sort of schedules in our own law schools. I think something you can also take up is support existing litigation, existing lawyers, who are actually working on these cases. So many of you all have actually mentioned about cases by social jurist Ashok Agarwal. I was actually reading this article by the moderator today, Dhruv. I'm asking this to you, Dhruv. You've written an article highlighting how, right to education applies to all children, including migrant Rohingya children who are currently being deprived education in Delhi. And you have a goldmine of information that you've presented in the research. And this petition is also pending before Supreme Court. So I would urge you, maybe you can actually talk to Ashok Agarwal, work with him, assist his petition, so your research actually becomes a part of the petition, and that actually might be one step in further convincing the court. So I think those are, I mean, what we do is technically, and I think given our culture, we think of our work as ending at a publication or getting an internship. We don't sort of think beyond. All I want you to do is not maybe for Dhruv, maybe just write an email or just text sir. I think that is all you need to do. Similarly, I think what I would also further say is that a lot of legal aid clinics today, given you all have such a strong volunteer network with law students, have a goldmine of information data set, which all of you through your surveys have combined. My urge to you on that would be combine all of that, bring together a state of nation report on RT. It doesn't have to be, I think in our panel, Professor Sareen pointed this very beautiful point that a lot of times we all, said that, okay, because we have surveyed only 15 schools, our, analysis is not very, it's a limitation in itself, just because we have looked at 15 schools. But no, think about 15 schools, the number of children you have actually sort of surveyed. And I think 15 schools, just because you have studied 15 schools, need not be a limitation, as long as you can sort of put your claim that in these 15 schools, this is the data I have. You don't have to necessarily put a generalization and have to sort of push your 15 schools data to sort of make a larger claim than you would want. I think going about sort of tackling that tendency, putting whatever sort of information you have, collating all of that, could actually be your contribution and actually connect, help a lot of RT advocacy sort of partners take it ahead with you. So I think that's also another bit of thinking you can do. Lastly, I will say is that after this event, I'm sure you have had experiences of your own, maybe learning the RT for the first time, maybe picking up something called the RT Bear Act from your library. It could be, say, visiting a government school for the first time for some of you. I think do document and reflect on these experiences, because I think those can be life-changing. And I'm sure that is an experience that you all carry today. And I'll just end on this note that, don't look at this competition or this event as just as a means to participate and, take a certificate. I think what you have before you all is sort of a stepping stone to exploring a career in RTE. And you don't have to necessarily, be an RTE lawyer. I would say that, one of my juniors who was working with me in GNLU in the Child Rights Center, she once actually interned with a retired, she was working as a judicial intern with a Gujarat High Court judge. And there was a bail matter. And in the bail matter, the sort of the person seeking bail said that, look, my child is going to be, sort of put out of that school. So I'm looking sort of, for a bail to sort of figure out that one new school because the wife cannot handle. And when this whole case was going on, the intern, actually, my junior, she went to speak with the judge, at the later hours and said, Madam, this case happened, but in the RT Act, the child cannot be deprived, and this sort of situation cannot be, compelled on the child. And the entire ground, if you're believing it to be true for this particular person, the child should not go through. And that small sort of nudge by that intern changed the judge's mind. Next time, actually, the judge called upon the education department to sort of look into this issue. And this was a bail matter, which had nothing to do with education. So I think even as little as sort of, experiencing RTE, you can sort of contextualize in whatever sort of line of career you develop, be it, working, in litigation. You can take up something completely different from RT. You can do policy advocacy. Maybe, you can do something beyond RT. But the amount of sort of the skill of identifying issues right? And advocating for it, I think those are the skill sets that today's lawyer needs. And that is something you can actually develop by working in this space. So with this, I think I'm sort of closing my comments and remarks. Over to you, Dhruv. Thank you so much. Yeah.
Thank you so much, sir. I hope that your words will really inspire the participants to also, in fact, even us to make efforts towards bridging the gap between policy and practice in RT implementation. With this, we conclude the panel presentations and we now open the floor for any questions from the participants. So you can feel free to either raise your hands or share your queries via the chat box, and we will take them up with the esteemed panelists. We have also received a particular question that is, what factors are behind such a distinction among the state policies? I think that this question is addressed to Mr. Manav, but anybody on the panel, if they are interested, they can answer.
I can try, then possibly people, those who are having law background, can also add to me. So based on, like education is in the concurrent list. So state always have, their rights to, change or do a little bit contextualization based on the state requirement. And sometimes I also find this is necessary as well. Because if you see the demographic pattern from state to state, it varies a lot. And so that much of, I think 20-30% of contextualization, that's necessary based on the state need. Yeah. Anyone can add to me as a Devalko, Nisha, Pooja as well.
I mean, just to add to that, of course, there are like the rules are written out differently because it's on the concurrent list, but it's also about the incidence of marginalized populations within different states, right? And then how those quotas appear on some level. So it's not like the state is also taking cognizance of the fact, and that's why it's on the concurrent list. They're sort of understanding that their population looks different.
I think this
we
is
have
answered. Yeah.
Yeah.
Go on.
Yes, sir. Yes. Continue, sir.
No, my point was this is, I think, answered this particular question. Nothing to add. Yeah.
All right. So another question was that what measures do you think would help ensure that children are not just enrolled, but are also learning effectively? Further, what, in your opinion, can be done to integrate these children with special needs into mainstream schools?
You want to go, Pooja?
You go first. I'll just start after that, Nisha.
Okay. Yeah, so I mean, on the learning piece, of course, everyone can add to it, but there is a certain like curriculum and pedagogy that we follow. In India, the way that our curriculum has been defined, and I think a lot of studies speak about this, it's sort of designed keeping the front benchers in mind, so to speak. So it doesn't necessarily take into consideration that different children have different learning speeds, have different sort of methods of learning. So there's a certain pedagogical training that maybe can be, improved, and in many cases with the initiative of individual teachers that is done. But in some sense, there is a level of standardization of schooling that maybe does not allow us to move around and play around with how to teach children effectively all of the time. And more than teach children effectively, it's about teaching all children effectively. A lot of the curriculum is geared towards, for example, we talk about this, right? Like rote learning and memorization. This is, of course, slowly, being or trying to be weeded out. A lot of it is about exam preparation rather than learning how to learn. A lot of it is more textbook based and less experiential. Like there's a whole body of sort of literature on pedagogy and curriculum that I think would be a nice way to sort of engage with that particular question. But this is, very brief. On the piece of integrating children with, say, disabilities or special needs, so I think integration used to be the goal, to say bring the child into the same classroom. Now the goal is very much inclusion. And what that means is essentially accounting for accommodations that a child requires to be truly included. So on the very basic level with a physical disability, you can say have ramps, you can have hand railings, etc., which bring the child into the classroom. That's your integration. But then to ensure the child is able to learn along with all their peers and also participate in every single subject, in all the extracurriculars, take the same exams, be graded on, fair ground. This essentially would be like true inclusion, right? So if you look at the PWD Act, there is an entire section that talks about education and inclusion of children with disabilities in mainstream education. And here you will find, I can maybe just put that into the chat box as well, but here you will find how they sort of speak about it. And the idea is to say that the school system should be able to make room for the accommodations that are required of students. Sometimes those are like technological aids, sometimes it's additional teachers who can sort of ensure that the child is being able to keep up, offer, additional support, things like this. Yeah. Sorry, go ahead, Puja.
So just to adding to Nisha, I think, so in RT 12(1)(c) as well, there are a couple of states who have made certain provision, and they have increased the age limit. For example, in Orissa, children up to 9 years of age can take admission in class 1, for example. So these sort of policies are there. However, sometimes school infrastructure itself sometimes is a barrier for that sort of education. The lacks human resources, skilled, trained teachers like who could teach the child with special need category, and also the infrastructure, the basic ramp, toilet facility, these sort of things are not there even. So, having admission, in so-called normal school, not for special needs school, is a mainstream school. And that's one part, and then after, retaining that child within that school, with an adequate, decent environment, it's another level of challenge. That's we are going through. Maybe in the down the line, if state government, a lot of discussions at the policy levels are happening nowadays. Maybe in the down the line, we can see some progressive steps from different states.
Yeah, everything is covered. Because if you're interested in the inclusion of children with disability in mainstream, quote unquote, mainstream education, definitely not integration but inclusion, as Nisha was mentioning. Number two, the onus is not on the child or the parent. The onus is on the system to include them. So that is a very clear distinction that needs to be kept in mind. Things have really moved forward since the passage of the RPWD Act. So things have definitely improved, and there's a lot of advocacy on making RT in tune with the RPWD Act. And you might also be interested in the recent amendment to the RTE Act, which has also included special educators in the PTR. So that's another thing that's very, very important and relevant here. And of course, there's a whole range of conversation on this. So this requires definitely a much longer discussion. Yeah. Hopefully this answers your question.
Right. We have also received a question from Ms. Shadab Kadri that this is directed for Rajkumari ma'am. So the question is that the major issue in the so the question is actually what should be the best practice to implement any law or policy effectively with respect to education? That is what I'm guessing. Ma'am, could you just
Ma'am, I
unmute
think you're
yourself?
muted.
Sorry. Thanks, Dhruv. Just to address this question, it requires a collective reflection. So, I'm just giving my point of view, but it requires a collective reflection. So, in my point of view, an effective implementation requires, in all aspects, from the governance, from budgeting, and in terms of teachers training, infrastructure facilities. So it requires a kind of an all-round focus. And what is more important is when that doesn't happen, a monitoring by civil society organizations or any non-governmental organizations, it requires. So that gives that push, that advocacy process or that campaign gives that push when doesn't happen. And one of the best practices that I kind of cherished in my experience working with teachers and schools is that we have a network of teachers in Tamil Nadu called Child Friendly Teachers Network. This is comprised of all government school teachers, mostly government school teachers. beyond the government initiative, they out of their own will and interest, they want to work and to implement practices. So they meet every like they meet quite often. They have organizational online discussions and forums to discuss best practices that they adapt in classrooms. And also they become advocates for change. So when I mentioned about the campaign that we did about prevention of child sexual abuse, teachers play a major role in advocating for changes in at a local level. So that brings kind of a real change. That one example, even you can find a BBC documentary on that. We have a school in Javadu Hills where there used to be only 10 children attending school in that school. And now that school has a strength about more than 600 children and centum result, all because of the dedication of teachers. So while teachers can play an important role, but it requires changes in all aspects. When it doesn't happen, teachers and the civil society organization can give a push. Thanks.
All right. Thank you very much, ma'am, for that. So as we have reached, okay, there is one more question. This would be the last question because we are running out of time. So, but Anand Shankar has asked that, what are your opinions on advancement of technology for streamlining the admission procedures and its effect on the awareness of children and parents, since digital access is indistinct in remote areas? So anybody who can take that up.
Devarga, you want to take it? Although like RT12 is being implemented through technology platform, but yeah, for access level, student access level, you want to share.
Madhav, actually, why don't you start with it? I can sort of maybe put some context. Yeah.
Yeah, sure. So with the state government, like where we are working, we are the giver end. Basically, we are supporting the state for technology development. So we have supported close to 10 states as of now as an organization, and set up their policy and then accordingly design their technology platform so that they can the policy could be implemented in a better manner and reach till the student level. So, but digital access, still there is an apprehension at the decision makers end. Like once we have some digital tool, then the problem is solved. Any digital platform or digital device can't work it alone, right? You need human intervention, you need human intention, you need adequate process, policies, accountability setting, then only some digital solution can work. Standalone, it can't perform. कुछ नहीं हो सकता है यार, हवा में तो काम नहीं करेगा ना कोई भी digital platform. So this is something, this creates this add more vulnerability in the system as well. Like if you have some digital solution to solve your problem, but people are not ready to use that properly, people are not capable enough to use that, then it will add on your problem. So this has happened, in a couple of times. So yeah, we could discuss more on that part, but yeah, due to lack of time. Devarga, if you want to add anything, yeah.
Sure, Manav. I think again, it's a sort of completely different tangent of conversation. We can sort of have another panel perhaps on just this, how do we integrate technology into RTE. I think something that in Project Sathi we recently sort of untapped was there was this sort of call for inputs by the UN Special Rapporteur on Education for Education, where they sort of wanted to understand integration of AI into advancing RTE. And the collective thinking we had at Sathi in my organization was that one is, of course, largely the literature on integrating tech into RTE is pushed towards, how do we make, children more tech savvy or the parents more tech savvy and the school more tech savvy. A slightly different position or thinking that we adopted was, how do we use AI or largely the sort of system of technology into analyzing existing data sets on sort of existing schools and understanding RT compliance. So for instance, we have something that you all have studied, the UDIS data. But in UDIS, if you just look at it as a standalone sort of system of data, it's difficult to navigate, how compliant is every school in terms of the basic norms and standards and the RTE. And not just RTE, but also sort of, new, Supreme Court led sort of compliance measures, say for instance, the Supreme Court once said that every school bus has to have certain compliances. So it's not just the norms and standards of the RTE, but the large literature that comes from PWD Act, the Supreme Court precedents. So how do we integrate AI into understanding the list of norms and compliance and sort of using existing government data sets that we have from schools to sort of map that? So that was sort of what we sort of went to the special rapporteur with, which was something which was cited in, I believe, in the GA, sort of UNGA report as well. But I think, yeah, that's just one way of thinking about integrating technology. It's just not that, we have to think of technology as giving a digital device to, a child and, just have a smart class. That's, of course, one way of thinking that is sort of still the largely dominant thinking. But yeah, how do we integrate this particular technology to make right space, access, advocacy, and delivery better? I think that's the larger course of thinking I would nudge you all to think on. But that's just one sort of perspective. I hope the question that you had, I'm sure that will require a lot more time. But this is, I think, the best one when I could sort of review to answer your question. Thanks.
Thank you so much, sir. Sir, I must say that the last 2 hours has been really thought-provoking for all of us. And as we have reached the end of this panel discussion, I thank all the panelists for dissecting the realities of the implementation with such nuance and conviction. I feel like your perspective has really reinforced the urgency of transforming what exists as a right into a very tangible outcome. So we are really grateful that you could take out your time out of a busy schedule to share your expertise with us. I would now like to share the floor with Bianca Bharadwaj, who shall be commencing the valedictory ceremony of the second NLUJ Right to Education paper presentation and discussion series.
To start off the valedictory ceremony, I would like to invite Mr. Ashish Gupta, former convener of the Legal Aid and Awareness Committee. He has also headed the inaugural edition of this event and has helped in conceptualizing this event. Over to you, Mr. Ashish.
Thank you, Bianca. I would just like to confirm if I'm audible and visible. Thank you. Good evening, everyone. My greetings to all the panelists.